I have read your motion, Ms. Gaston. Um, is there anything you'd like to add to it before we hear from Ms. Mahoney?
Just briefly, Your Honor, as you may recall, we were here on March 28th of 2025 on an initial motion. The ruling following that motion was to follow the status quo, but that if we were unable to resolve the issues, to come back to you and you would, I don't know, do something, send it to the front of the court, whatever. Since that time, there have been a total of 15 police reports obtained between 2022 and January of 2025. I believe there are more out there now, but my FOIA request obviously was only through the date that I asked for it. So we've had to re-FOIA. The parties had entered into some temporary agreements, which were to include parenting time beginning for my client on the 4th of July. On the 5th of July, Miss Ray, as I hope the court has read, contacted the police wanting to know where the child was during my client's parenting time, because he was at a park and during his 4th of July celebration on the 5th with the child. And when the police wouldn't help her, she went to Facebook and tried to put out sort of an Amber Alert. Subsequent to that, Your Honor, which you may have gleaned from the response, the plaintiff was hospitalized at Pine Rest due to mental health issues, and she was there from July 8th to July 16th. I did not receive the records from Pine Rest until July 24th, and Miss Ray now wishes to return to this Thursday through Monday morning parenting time that had been put in place because, as you know, the paper does not reflect that my client had custody and he had relented at some point towards the beginning of her filings to this Thursday through Monday morning parenting time. And that's every week. He also has Fridays off, and he also is off on weekends. So we've been angling to go to an every other weekend type schedule, but now we're very concerned about the safety of the child in Miss Ray's care. And so my client is really seeking supervised parenting time pending some stabilization period. The medical reports say that she appeared stable upon release, but then the pleading indicates that she was already in med reviews with monitoring medication. So this is not a new mental health disorder. It may be contributing to all of these police activities that we've discussed in the pleading. And I didn't attach all of them because it would have been voluminous. But essentially, that's our request, Your Honor, and that we either get an immediate evidentiary hearing or go to the front of the court. Miss Ray seeks full custody, just a return to as if there never was a 3-year lapse in parenting. So that's why we're unlikely to resolve it in mediation, which was scheduled, so the court knows. It's just that Miss Ray had this mental health breakdown and we weren't able to, accomplish the mediation and felt like we needed to get here sooner rather than later. Thank you.
Thank you. Before I turn to Ms. Mahoney, my information indicates that someone, I understand why mediation was canceled. It's doesn't make me particularly happy, but I understand. But what I'm getting word is that mediation was canceled because someone said it was inappropriate to mediate. Do you know who said that, Ms. Gaston?
I do not, Your Honor.
Okay. All right. And you would agree with me, from my review of the record, an ex parte motion was denied by Judge Gottlieb on July 11th of 2025. Is that accurate?
It is accurate. And what's strange about that is the order itself says, CPS should be the ones to get involved here. Both parties have called CPS. CPS has been to my client's home many times and not substantiated any of the claims. We can't be calling law enforcement and CPS at the drop of every hat. So we need to resolve this in a timely fashion. I forgot to comment, Your Honor, that I have had an opportunity to review the Sims v. Verbrugge case, and that's a 2017 Michigan Court of Appeals published decision. I don't think my client needs to reach that threshold on the issue of joint legal custody, and I certainly think that he has reached the threshold, so to speak, on physical custody, given that they weren't operating under the then existing order.
Thank
So,
you.
thank
Ms. Mahoney.
Well, Your Honor, I think I'll kick off with the easy thing. First off, Ms. DeHaan indicated that she has no objection with this going to front of the court, and she in fact thinks it would be helpful. I'll note that Ms. Gaston said that mediation would be canceled because of my client's hospitalization. While our client was hospitalized at the time, it was my understanding that there were emails from both parties or both attorneys back and forth indicating a desire to reschedule mediation even before this hospitalization. So I think that to characterize it as completely being because of my client's health care is a little bit inaccurate. I think that the issue was that the parties were kind of feeling that front of the court may be a better route to go, and they were discussing an agreement to move the mediation. And then ultimately, my client's health issues kind of did factor in because it overlapped with the same date. But I don't think that this was a situation where that should be solely put on Miss Ray. As far as the issues with supervised parenting time, I'd first note, much is made of these police reports, Your Honor, from 22, but I would note that a lot of them were from 2022, 2023. The orders that are in place now clearly reflect that this parenting time arrangement was based on a status quo with the parties. So even with this police activity, I know he's saying that he just found out about the police reports, but essentially he's acknowledging that during that entire time, she had this parenting time. There were no concerns. Ms. Gaston even noted that CPS has not substantiated any concerns. As far as the allegations that are more recent in the ex parte, I mean, certainly we would acknowledge that that Facebook post was not appropriate, and I think my client is prepared to acknowledge that. But I think the issue was that she was going through a medication adjustment. That had to be done slowly, and ultimately she needed more help than what that slow increase in medications could give her, and that's why she was hospitalized at Pine Rest. I have a letter from her physician that indicates that she was admitted on the Aspen unit from 7/8 until 7/16, initially presenting with concerns of paranoia and difficulty taking care of herself. She was then started on medications, was provided with various group therapies. She did well in the unit and responded to medications. She showed significant improvement and appeared stable at the time of discharge. My client is now continuing to take care of her mental health. I would note that there are no allegations in the ex parte order or otherwise that she ever posed a threat to the minor child. She was not threatening his safety. Her hospitalization occurred while he was with his father. And I think that this is a situation where she had an isolated health event. It's connected to that Facebook post, but that isolated health event is currently being treated. And at no point is there any indication that she was treated for a suicide attempt. At no point is there any indication that she posed any threat to Theo. I'd note, Your Honor, you already raised the fact that this ex parte was denied. That letter from Pine Rest was provided to Ms. Gaston, and at this point it's been indicated that Mr. Wolf does not want to return to the parenting time until you weigh in. I think it's a little interesting that the position here is that the concern is that my client won't return the child during parenting time, but in fact, right now, she's the one who's been denied parenting time. And I know Ms. DeHaan has been trying to be respectful of that, given some of the allegations here, but ultimately, Miss Ray was following the orders, and Mr. Wolf now has decided that he's not going to agree to any parenting time unless and until you order it. I think at this point, Your Honor, given the situation, given the fact that her mental health is stabilized, that she was never an imminent, she never posed any threat to the child. There's no CPS involvement. I think it's appropriate for the court to go ahead and resume the current schedule, which is reflective of the status quo that the child is familiar with. And from there, schedule us for hopefully an FOC investigation and then ultimately an evidentiary hearing on the broader issues. But I just don't think that there are any indications that it would be harmful to the minor child to switch it up from what the parties have done and what the child knows. Thank you.
Thank you. Ms. Mahoney, who is Malachi?
That, I believe, is my client's former partner. I know Ms. Dahan indicated in her response that there was a domestic violence incident in January. My understanding is that they have separated. She is working with Safe Haven. She is not in an ongoing relationship with that person at this time.
Thank you. Ms. Gaston, I'll give you the last word.
Thank you. With regard to Malachi, Your Honor, he's been an on and off boyfriend for several years, and many of the police reports involve him. They did not separate in January. They may have separated in June. That's my understanding from opposing counsel. I don't have any documents, and we don't know a date, and we don't know what happened that ultimately resulted in the separation. The child has been exposed to many of these incidents, and that's what's reflected in the police reports. I'm not certain what would have happened to the child had he been present during her mental health breakdown. I have indicated that there was some rude behavior on the part of Ms. Ray towards the child during a ice cream incident with Malachi, which she has denied. I do think there are dangers. And with regard to any denial of parenting time, Ms. Dahan and I had discussed that once I had the records, that we would revisit what we would do with parenting time. I didn't get the records from the actually, they're not directly from Pine Rest. They're what Ms. Ray provided, except for the letter sent until the 24th. So if there's been any denial of parenting time, it would have started last night, Your Honor, and we thought we were headed here today. It just made prudent sense to take this matter before the court, because ultimately the court is the truer fact in this particular situation.
Thank you both very much. Let me first say that I appreciated the submissions by both parties. I thought they were well written and very clear. As both you, Ms. Gaston, and you, Ms. Mahoney, know, the Board of Appeals is rather cranky when it comes to changing things up on a Friday morning without an evidentiary hearing. The latest case of Beretta versus Zitoff, 348 Michigan Appeal, 539, a 2023 case. There's also a 2025 unpublished case of Kleinfeld versus Stern. That is also suggestive of, even though I certainly am concerned about some of the behavior going on here, I don't have the docket space to tee up an evidentiary hearing that fast. I wish I did. But what I am going to do is this, because Ms. Gaston correctly framed the issue, is we were going to give mediation a shot. If it worked, it worked. If it didn't, then the parties would come back here and I would rule on threshold. The first thing I'm going to do is find that proper cause or change of circumstances has been shown relative to physical custody, child support, and parenting time, pursuant to Vodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case. I find that the issues of domestic violence, the issues of the possible mental and physical health of the parties involved are directly implicated. Best interest factors found in MCL 722.23, that would be item K and item G. So what I am going to do, I will also tell you that my reading of Sims versus Verbrugge is spot on with Ms. Gaston's 322 Michigan Appeal 205. And that case basically said if there hasn't been a judicial determination of the issue of legal custody, then there is no necessity for showing change of circumstance. So I will refer all those issues out to the friend of the court for an investigation and recommendation. As I typically do, when I have legal aid on one side, I typically waive the fees for both because I think that's only fair. So I will waive the fees for both. I'm also going to direct that a psychological exam be performed on the plaintiff. Some of the things that I've read in there, while not causing me enough to jump into clear and convincing evidence to suspend things, they're concerning. Obviously, I know that Ms. Mahoney and I agree that was wildly inappropriate to do that on a Facebook post. And I want to see what's going on. So I'm going to order a psychological. I have not seen any evidence to suggest that Mr. Wolf would need that same type of treatment. I am going to reserve any tinkering with the parenting time schedule. I want to see how things go in this next few months or month. And if things somehow get really concerning, then you certainly can bring that back, Ms. Gaston, by way of ex parte order for Judge Gottlieb or on my motion day. And hopefully we'll see if we'll take her current psychologist at her word, or at his word, I'm sorry, that things have seemed to be stabilized. But I will do the order of reference myself this morning. But if you could, Ms. Gaston, prepare a separate order requiring psychologicals by plaintiff, and this court is going to order that there be no contact between this individual, Malachi, and the minor child. Period. End of story, full stop. We will take care of that issue as well. Ms. Gaston, any questions on what I need the order to say?
I don't believe so, Your Honor.
Thank you very much. Ms. Mahoney, anything further from you?
I guess, Your Honor, I know this is probably not likely to be granted, but given the extreme cost of a psych eval, I'm just wondering if there's any possibility to just reserve on that issue pending the FOC investigation. I know that that can often be prohibitively expensive for legal aid clients, and I'm wondering if FOC, upon the opportunity to review her medical records, may have a different take on this.
Well, I tell you what I'm going to do. I have resisted saying a psychological at a certain place because obviously Ms. Gaston may, based on what she reviews, may consider that her treating psychologist is okay for this. But maybe she won't. I don't know, because I don't think she's seen all of the records yet. But I will reserve that, Ms. Mahoney. I'm not trying to put anybody into bankruptcy court, but I need a psychological that ferrets out why some of these concerning behaviors are happening.
Thank you, Your Honor.
If you
Your
could,
Honor, in that regard, I don't have a release, and I wonder if the court would grant me a release of her record. Otherwise, I won't be able to review them. And secondly, at the moment, my client pays child support based on a 50-50 custody schedule. So I wonder if the court would suspend support on his behalf. Thank you.
support should be calculated on actual overnights. I mean, if it's not 50-50 right now, then it should be calculated on the overnights using the figures they already have. As far as obviously what was the first issue you brought to my attention, Ms. Gaston?
A release for the psychological record.
Well, obviously, the plaintiff's mental state is very much an issue in this case, Ms. Mahoney. So I will direct that she sign all appropriate releases so that Ms. Gaston can get the information from whomever she's treating with, because quite frankly, that may, after reading those, she may say, okay, we can go with this psychologist. Maybe not, I don't know, but I'll direct that be signed within 14 days. If you could put that in the order.
I'm just wondering, because I know that appropriate might be subject. I assume that would be subject to the ability to Ms. Gaston and Ms. DeHaan if they have a disagreement on what is an appropriate range or sphere of the releases, that they can come back to you for clarification if necessary.
If they need a protective order, then that's fine. But normally what I ask of attorneys is that these records not be disseminated to their clients. And attorneys are usually pretty good about that. So that kind of takes the thing out of the protective order. But see if we can get this case back on straight and narrow. Thank you both very much.
Thank you,
Ms. Gaston, Ms. Mahoney, for subbing in, and we're adjourned on that matter.
Thank you.
Good morning.
I'm somewhat surprised at everybody's appearance here today, because usually these never go, because one party orders a transcript, sends it to the other party, and that other party says, yeah, you're right, or no, you're wrong, or let's fix this, and everybody goes into the abyss. But apparently that's not happening here, and I don't know if that is foretelling me that we're going to be having difficulties all the way through this case, and I hope not. But I read your motion, your objection, I should say, Mr. Cox, and I read the response, and I'm trying to see what exactly the issue is, because I don't have a transcript in front of me. I know there's probably one on the court file, but this seemed like, as I remember, we were simply, when I extended parenting time to allow for 2 other days, that was the only thing that Ms. Johnson changed relative to the child support. Everything else was the same, and my intention was not to give the parties a second bite of the apple as far as child support is concerned, because that ship has sailed back then. unless somebody wants to file a motion alleging significant proper cause or change of circumstance. So shed some light on this for me, will you, Mr. Cox?
Yes, Your Honor. Your Honor, first I would like to say that Ms. Johnson has been really easy to work with. She is very interested in settlement. She has been very fastidious in terms of working with me. We even talked yesterday a couple of times. And I agree with her, Your Honor, that this order should be entered. And I agree with you that we shouldn't be here fighting over it. The hang up is that my client is not comfortable with the parenting time schedule and not comfortable with the overnights. And that's why I explained that I can't agree. I should agree, but we're stuck on the parenting time issue. And I think that's kind of really it in a nutshell.
Didn't I already rule on that?
Well, again, my client is indicating that she is not comfortable with him having 2 overnights per week. And I've, explained these things to her, and she, wants me to continue to argue that those 2 overnights are not appropriate during the week, and there should only be 1 overnight. And that's kind of where I'm stuck here, Your Honor.
Okay, I understand. Ms. Johnson.
Your Honor, at this point, I would just ask that you enter the order as presented by myself on behalf of my client. In the objection, it appears that it's about the income figure for Mr. Ronaldo, which I believe I've tried to discuss with Mr. Cox's office to explain to him the procedural history, because he was not present at that initial objection. Ms. Jermal had another attorney. Now it sounds like the issue is the parenting time order, but I think, as Mr. Cox has agreed, the court did order the temporary parenting time as stated in the proposed order. And if Ms. Jermal has an objection to that, of course, she'll have to file a de novo with the judge related to that issue. And I do believe the order as presented is what the court ordered.
Yeah, I mean, obviously, what I try to do always is I try to get it right. But many times people have different issues with what I do. And that's fine, because most of the time, family law is a 50-50 proposition. Half of the people are upset, half the people are satisfied. But obviously, when I made that ruling, I think that was sometime in March 28th, maybe, that was already a ruling of this court. I might have even done it at our case conference on the 14th. So I am going to grant the motion and enter Ms. Johnson's order. I am going to, at this point, reserve attorney's fees for Ms. Johnson, and because they haven't been presented in the proper form yet anyway. And if this ends up going through an evidentiary hearing, there will very likely be an award of attorney's fees, especially for this motion, because I don't think it's necessary. So I'm going to sign your order, Ms. Johnson, and if you want to prepare a separate order reserving your attorney's fees and what that amount is, I will consider that if and when we end up in an evidentiary hearing. Do you have any questions about what I need that order to say?
I do not. I would just note that there's an order and accompanying UCSO.
Yeah, I'll sign them both. Mr. Cox, anything from your end?
Nothing further, Your Honor. Thank you.
All right. Thank you both very much. I wish everybody the best of luck in this. And we're adjourned. Thank you.
Thank you, Your Honor.
Thank you.
I take it that the plaintiff is in fact the guardian. Is that accurate, Ms. Smithblow?
It is correct,
Right.
Your Honor.
Well, then, good morning to you, Nanette. Appreciate you being here.
Good morning.
So, if you will permit me, Ms. Smithlow, a complaint was filed under a DC or DZ case code on May 5 of 2025. It was served on May 22nd of 2025. The defendant provided an answer on the 23rd of May of 2025, and a pre-hearing conference was scheduled for 6/24 of 2025. Based on the child support guidelines, utilizing incomes of 0 for the guardian, you never use the guardian's income, and actual for defendant with 0 overnights. Ms. Smithlow calculates child support at $486 in base support, $33 in ordinary medical, for a total of $519 per month. When there's only one child subject to the calculation, the amount is $454 per month, 17 in ordinary medical, for a total of $471 per month. The uninsured medical split is plaintiff guardian 0 and defendant 100%. The 4D birth expenses were also waived. However, application of the Michigan child support formula in this case is alleged to be unjust and inappropriate pursuant to the Michigan Child Support Formula Manual, section 1.04, subparagraph E as in Edward, subparagraph 18. And the parties agree to the following modification, or as we say, deviation in child support. When there are 2 children subject to the calculus, the amount is $167 in base support, $33 in ordinary medical, for a total of $200 per month, commencing August 1 of 2025. And when there's only one child subject to the calculation, that amount is $133 in base support, 17 in ordinary medical, for a total of $150 per month. In all other respects, all the matters such as custody, parenting time, are as previously ordered by the Kent County Probate Court in case 22-0025, 23-GM, and 22-002522GM. Ms. Lowe, is there anything you want to place on the record before I inquire of the parties?
Yes, Your Honor. We did conduct a pre-hearing conference together on June 24th and 26th, I believe. Spoke to both parties, and one of the reasons that it was the calculator was unjust for the and appropriate for deviation is because Nicole Tingley does have overnights with the children, but the calculator, with a third party guardian, the calculator would not allow me to make that adjustment. And it was Miss Martinez's, it's her desire to allow to have this deviation so that the children can return to their mom, and that she can afford to do. I'd let her voice that to the court.
All right. Why don't we hear from our guardian, Nanette, and then we'll hear from Ms. Tingley. anything you want to add, Ms. Martinez?
Nicole is, I mean, I don't really know what to say because I thought we had agreed upon $200 a month, being that the goal is to try to get her to get her kids back. And right now life is hard and it's a struggle, you know. I can't expect her to pay me $500 a month, get a place to live, and provide for her kids.
Yeah, I agree.
Like, so, you know, I feel like $200 a month, you know, $200, $300 a month. That way it gives me a little bit. She helps out. And then, you know, and it pays for Medicaid. You know, we're trying to be work together, not against each other. This was supposed to be, I'm grandma, she's mom.
Yeah,
She's working on that.
I think it's a good idea.
Yeah.
And we did have an agreement, Your Honor. Both parties consented to the deviation. The documents were sent through DocuSign, but for some reason, I don't know if it was a glitch in the system, the documents weren't signed.
Huh. I don't know. Well, Ms. Tingley, what can you tell me? You're on mute, by the way. So if you could.
I'm sorry about that. I did not know. I agree with my mother. I have no problem paying the 200. I thought that that's what we agreed on. I didn't know that we were supposed to sign anything, but I do plan on getting my kids back. It's just hard getting housing, to pay for housing, to be a single mother with 2 kids. So I appreciate the help from my mom, because if I didn't have it, we would probably be in a shelter.
Okay.
But
I think
it's
that's
kind of hard to get house help as well.
right. Housing is the crisis of this
Yeah.
century for sure. So I'm going to go along with that deviation, Ms. Smith-Lowe, and deviate down to $200 per month, commencing 8/1 of 25, and then I will sign the remainder of the order. Obviously, most of the provisions in that order are always going to take a back seat to the guardianship, as Ms. Smith-Lowe noted in her motion. But I will sign on to the same, and we will set that child support at $200 per month.
Thank you.
Okay, anything
Thank you, Your
further,
Honor.
Ms. Smith-Lowe? All right, you are all set then, and thank you for being here. And you can sign off. We're adjourned.
Thank you.
Thank you.
This case is kind of a pebble in my shoe. And I'm trying to work through it. And I'm happy to report, Ms. Smith-Lowe, that that Mr. Tui filed a divorce matter on June 13 of 2025.
I see that, Your Honor.
It needs a ROPA motion. If it were a paternity case or a DS case, I think the court would do that on its own volition. I'm not sure that they do that on a paternity matter, or I mean on a support matter in this situation, but your thoughts of how we should proceed as far as, I mean, we're making progress. I wish the progress was a little bit more substantial, because I don't want to keep having to drag you back here, but it sounds like to me, once this genetic test is done, it's probably going to eliminate Mr. Toey, but you and I are both not mind readers. So
Right.
your thoughts as to how we should proceed?
Your Honor, I'm assuming that in the divorce case, we would get if a motion is filed that the children were born out of wedlock.
Yeah, that we would get
that would
that.
resolve our case.
It would.
But I don't know whether or not genetic testing has been ordered in the divorce case.
It has not, only because I don't think Judge Gottlieb would do that just as a matter of course on on a DS case without having a companion ROPA motion, unless it came from your office. So what Mr. Towie needs to do is he needs to get to the Legal Assistance Center, file a motion in the divorce case requesting that this child in question be declared a child born out of wedlock. And once we do that, and I have a very short best interest hearing, then Mr. Towie, that would remove you from this situation and make Ms. Smith-Lowe's life a little easier over there too. So, but I need that done sooner than later, okay? So I need you next week to go to the Legal Assistance Center, and I want that ROPA motion filed by the next motion day, which is mine. I think it is August 14, maybe.
Yes,
So
August
I'd like to,
15th.
August, one of the two. My next, I'd like it filed by my next motion date, Mr. Towie, okay?
Okay.
All right, and then that way I will adjourn this one more time, Ms. Smith-Lowe,
Okay.
and hopefully we can get to the bottom of this once and for all. But we're getting closer, baby
We're getting
steps, I guess.
We'll have to wait for genetic testing, of course.
Of course, absolutely.
Okay. So I won't re-motion until I'll watch the DM case.
Okay, and see if there's and then once we get that genetic test, then I'll run a quick best interest hearing, and then that will put this matter to bed once and for all. Okay.
All right. Thank you, Your Honor.
All right. Thank you. And Mr. Towie, get busy. I want to see you next week with a ROPA motion. Okay.
Thank you.
You bet. We're adjourned. Nice to see you, Ms. Towie. Good morning again.
Good morning again.
And unfortunately, the plaintiff, Ms. Jacques, or Jackways, however she wishes to pronounce it, is not with us today. But if you will permit me, Ms. Rummel, a complaint for paternity was filed on January 22nd of 2025. An answer was filed on February 12 of 2025. An order for genetic testing was entered by the court on the 19th of February of 2025. The genetic test results were filed with the court on May 12 of 2025, which indicated to a scientific certainty that Mr. Keenum is the father of the child in question in this case. A pre-hearing was scheduled for June 10 of 2025 as well. The child support guidelines is calculated by Ms. Rummel and her office is $174 in base support, $17 in ordinary medical, for a total of $121 per month, commencing March 1 of 2025. The uninsured medical percentage is 0 for the plaintiff, and the defendant is at 100%. The incomes were actual for the plaintiff and potential for the defendant. And I have considered all the factors set forth in the Michigan Child Support Formula Manual, specifically section 2.01G as in George. And I found that application of those factors was made and is appropriate. There's 0 overnights used in the calculus. The 4D birth expenses were waived, and genetic cost testing will be added to the child support amount, and that is $66 which they will take out at an extra $22 per month. Ms. Rummel, is there anything you would like to add, or do you wish to wait for Mr. Keenum to give us his thoughts?
Nothing at this time. I'll wait for Mr. Keenan to give us his thoughts. Thank you.
Okay. Mr. Keenum, you can unmute and tell me what's on your mind.
Yeah, I'm perfectly fine with that.
Okay. Then anything further, Ms. Rummel?
No, thank you, Your Honor.
Okay, then I will go ahead and sign on to that judgment of paternity, as well as the companion uniform child support order. And Mr. Keenum, I wish you the best going forward.
I appreciate it.
You are all set with me. Thank you very much.
Thank you.
Good morning.
So if you will permit me, Ms. Rummel, a complaint for child support was filed on May 9 of 2025. It was served upon Mr. Jones on May 22nd of 2025. The defendant filed an answer on 5/28 of 2025, and a pre-hearing was scheduled for July 1 of 2025. The child support guidelines, as run by Ms. Rummel's office, provide for $648 in base support, $11 in ordinary medical, for a total of $659 per month, starting June 1 of 2025. For incomes, the plaintiff was imputed income or potential income, and the defendant was actual income. I have considered the factors found at Michigan Child Support Formula Manual 2.01G as in George, and I certainly find those to be appropriate in this case. There are 0 overnights at this point, and the Section 4D birth expenses were in fact waived. The uninsured medical percentage split, 36% for plaintiff, 64% for defendant. Ms. Rummel, you wish to make any statement, or do you wish to wait until after Ms. Thomas makes a statement?
Nothing at the moment. Thank you.
You bet. Ms. Thomas, anything you would like to add?
No.
Okay. Anything further, Ms. Rummel?
No, thank you, Your Honor.
All right, then, without objection, I will sign on to this judgment of support. Your wonderful staff, Ms. Rummel, can send that to me via DocuSign, and I will sign the same. Ms. Thomas, I wish you the best going forward. Nice to see you again, Ms. Rummel, and have a great weekend. We're adjourned.
You as well. Thank you.
The defendant joins us, Mr. Philip Gillespie. Mr. Gillespie, good morning.
Good morning.
So, Ms. Walker, I have read your motion. Let me just confirm that Ms. Lopez got a copy of that as well.
I actually just received it this past Wednesday, the 30th.
Okay.
So I didn't have a time to respond, but I did receive it.
Okay. Any reason why the mail was running late?
It could be because she listed my name as just Jasmine Lopez, or the zip code had an extra digit in there.
Could be. Well, what I always do if there are some issues as far as notice is concerned, I will give you the option. We can proceed today if you're comfortable doing that, or we can adjourn and come back, and now you have the documents, and we can take it up from that spot. Which would you like to do, Ms. Bennett?
I would like to adjourn so I can submit proper response.
Okay. And I hope those responses aren't chock full of text messages.
No, they won't be.
Good. Anything you want to add, Ms. Walker?
Certainly, I know the court would adjourn if someone states that they haven't received it. I believe the issue why Ms. Bennett has not received that because she has left the state of Michigan. And this was sent to her address, which is her last known address. We don't have a current address for her. There is an ex parte order that was issued that says she was not supposed to leave the state of Michigan. And in fact, we have reason to believe that she has left the state of Michigan and is now in Arizona. I know that matters not before the court today, but there was no issue with notice. This was mailed out immediately to her. And I believe that's the reason why she didn't receive it. If she says she's not, if what she's saying is accurate.
Yeah, I don't fault. These things happen. The only reason I like to catch these early is so it doesn't mushroom into a big issue that later on we have to try and fix. So it'd be easier, a lot easier, just to renotice this for my next motion date, and then we will tackle this case. But I will tell you this, is if there is an order by the court that prohibits somebody from relocating to another city, that could end up to be very problematic. I don't need to cover that today. It's not in front of me today, but I always am concerned when there are allegations of violating orders. Those are always very difficult cases. So to the extent that anybody's orders being violated, I suggest they straighten that out by the next time we meet. So I'll have you, Ms. Walker, if you would be so kind to renotice this matter. And I will approve email if you have her email address. Ms. Walker.
I don't have her email.
You have an email address, Ms. Bennett?
I do. It's jbennettLopez@gmail.com. Your Honor, I would also like to say that there is a current order of protection against Mr. Gillespie, so he would not have access to any address information.
Yeah, obviously, there's a lot of complicating factors when parties start getting a bunch of different orders. But we'll see if we can't work our way through it. Well, we'll adjourn it a couple of weeks. So thank you, Ms. Walker. I appreciate your input on this. Ms. Bennett and Mr. Gillespie, thank you both very much. And I will see you all in 3 weeks. Thank you very much, or 2 weeks, I should say. Thank you all very much. We're adjourned. So I have received a copy of a objection to the friend of the court recommendation. I wish I didn't, but I do. And because it's things start moving at a quicker pace than that. So let me just create a record, and then I'll turn to you, Mr. Hexel, and then we'll turn to Mr. Zirkle. So this matter was previously in court on the 19th of May of 2025. Parties actually stipulated to a child support review, and an order of reference was entered on May 20th of 2025. On June 30th of 2025, the court received the friend of the court child support recommendation and orders. On July 17th of 2025, plaintiff filed an objection. Therefore, it was a timely objection. So where it goes from here, folks, is it gets exponentially more complicated. And we set the matter up for an evidentiary hearing. Usually on child support, Mr. Hexel, I start with an hour, and then we work our way on from there if it needs to go further. But when you get notice of this evidentiary hearing, it's also going to have some very important filing requirements: briefs, witness lists, exhibits, exhibit lists, those types of things. And failure to do those things or do them correctly could result in your hearing being postponed or adjourned, or if enough of them happened, even canceled. So pay particular attention to that. If anybody is considering hiring an attorney for this matter, then they ought to do so in the real near future. Also, the date for these must also be cleared through the friend of the court evaluator, whoever did the evaluation, to make sure they are not tied up in another hearing or on vacation or on medical leave, so we don't have to adjourn that matter. So, Mr. Hexel, I have one question, and then I'll turn it over to you. Normally, I always inquire in these cases if you think mediation would be an appropriate avenue to try and settle this, or is that just not an appropriate way to do this?
Your Honor, I would actually defer that question to Mr. Zirkle. I'm always open to mediation. I believe it's a great process and a great opportunity for these clients to work this out themselves without litigation. And I think Ms. Zirkle would be willing to do that. So I would defer to Mr. Zirkle.
What do you think, Mr. Zirkle? You think a mediator can help get these issues resolved?
Your Honor, I have been trying to settle on this matter. Mr. Hexel is a fabulous attorney and a great salesman as well. But his general accounting practices are, I'm not really seeing how he's getting these numbers. I wasn't a huge, fan of the FOC result. I thought it was rather high because they did factor a bonus in there. So I just, went with their professional opinion and thought it was going to be okay, and I was going to go with it. However, as you see there, the plaintiff wants even more. And then not only even more, but to continue to do this every single year. If you look at our past history, the plaintiff has filed multiple motions every single year since the judgment of divorce. It's kind of a living hell looking at my email and just being fearful of another email from Jonathan Hexel. I respect him as an attorney, absolutely. However, they've caused a lot of grief, and I would just really don't want to just bend over to these terms. I think that the FOC statement is, yes, high. I'm willing to go with it, but for them to ask for even more, I got to draw the line somewhere. I do believe that we should, if they do in fact want to fight this, we should take this to court. There are a lot of things that I would like to subpoena. There is a family business that wasn't factored into the FOC judgment. I think that those figures need to be presented. I'd like to see a profit and loss statement of the Groundhog organization where Kaylin works, and it's a family-run business. So I know that there's multiple incentives along with that. I can understand too if, say she was a single mother living on her own, but she is like very well compensated, drives a brand new truck, lives in a big house with her extended family. I don't see a reason for wanting even more. Even seeing how there was a sign-on bonus and a incentive bonus factored into the calculation. So say next quarter I don't get those bonuses, I'm still paying that $1,080 a month, right? Which is 8 times the typical child support payment for the amount of nights that I'm getting as well.
So, we're off to a bad start, you and me. And I'll tell you why. Because I just asked you if you thought mediation would be appropriate, and then you've gone into a 10-minute dialogue and answered and asked and everything but what I asked for. Okay. We're not here to try the case. We're not here to get your thoughts on the case because there's been an objection. It's not that your thoughts aren't important. They're just not important today because what I have to do when there's an objection is I have to set it for an evidentiary hearing. But I try and ask the parties if they believe that a neutral third party couldn't help them with the possibility of getting this matter resolved once and for all. And I was just looking for a yes or looking for a no from you because mediation adds an expense, and I don't want to do that if the parties are not mindful of its ability to resolve the case. So let me try it again. Do you feel mediation would be beneficial? Yes or no?
My apologies, Your Honor. No, I do not.
Okay, then we'll set it for an evidentiary hearing. And you can get with my clerk, Mr. Hexel, probably starting next week. You also get with the friend of the court, whoever did the evaluation, and then we'll get it teed up for about an hour. Mr. Zirkle, I would, based on what I've heard today, I would strongly urge you to retain counsel because some of the things you are asking for, although relevant, may be difficult for someone who is representing themselves to get. So, but the Sixth Amendment lives alive in my courtroom, so you are free to do this on your own. And hopefully things will work out for the best. Otherwise, we'll see everybody in court. Make sure you keep in mind the filing requirements, submission requirements, and we'll get that squared up for you. You're all set with me. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
So this is your motion, Mr. Shears. I have read your motion, and I have also received a response from Ms. Lachey, and I've read that as well. So my first question will be with the plaintiff. Have you received a copy of the motion, Mr. Lachey?
Yes, I had to go down to the court. Oops. Can you see me? My screen is freezing.
Yes, I got you.
Okay. Yep, I got it from the county clerk.
Okay.
Last week Friday.
And Mr. Shears, did you receive a copy of her response?
No, I have not.
Your Honor, I do have a receipt here from the Postal Service saying that it was mailed to that address.
Okay, it says, well, and there's a proof of service that says 725. But do you two generally communicate at all, or are you two not even doing that?
No, Mr. Shears, he does reach out to me on Messenger, so he does initiate communication on his end, but I do not respond.
Okay, I am, because what I would like to have done is I would like him to have a copy of your response, and I'm trying to see how the best way to get that to him, whether it be in the mail, but the easiest way to do it is to scan it and email it, so he gets it immediately. Do you have an email address, Mr. Shears?
Yes, I do.
Why don't you give it to me?
It's my first name, Jelani, Jelani, Shears, Shears, at iCloud.com.
You got that, Ms. Lachey?
Yes.
Okay, so just scan it and ship it over by email, and then he's got it, and you can read it later today, Mr. Shears. But I have read your motion. Is there anything you would like to add to the motion before we hear from Ms. Lachey?
No.
Okay, thank you. Ms. Lachey, your thoughts, please.
Because I don't want to go on a tangent. However, with me receiving this last minute, I did not have enough time to allocate evidence to show, but showing up today as in good faith, I always try to do what's best for the children. We have a FOC case as well. On the documentations, it will show his inability, like there's a pattern. He doesn't have a stable housing. I'm unsure why he did not receive the motion because I used the address that was listed on the motion. Also, him filing incorrectly. I'm also looking into getting his rights terminated because this has been a lot where the kids are in therapy. I've gone to therapy myself, and yeah, I just don't want to go on a tangent. That's all I want to say.
Okay. So I have, here's what I know. The parties appeared for mediation at the front of the court on February 11 of 2025, and the matter was not resolved. And I want you both to remember that when this case concludes, because I will almost guarantee you both will be kicking yourself for not taking advantage of that mediation, because this is really the last opportunity to control your own destiny, so to speak, in this case, because now it goes from the parties being able to sit down and maybe not come up with a perfect solution, but one that they can work with and go into the future with. But now I have to get involved with it, and a lot of people don't like when courts have to make decisions about kids they never met. But maybe this will work out for each one of you. I don't know. The last parenting time order was the March 5 of 2019 judgment of support. Parenting time was set by the agreement of the parties. According to the motion, and there's always more to it, I know that, but if I've heard this once, I've heard it 1,000 times on these motions. Motion states everything's going great, and then the parties have an argument and it stops. I hear that constantly, and I know there's obviously two sides to every story. That might not be how Ms. Lachey sees it, but be that as it may, there are irregularities in service. I get that. And I'm always willing to tell the other side that I would be happy to adjourn this matter and for a couple of weeks and then allow for proper service, that type of thing. But I will tell you, I'm going to do what I'm going to do regardless. So if it probably would not behoove you to take time out of your days to do this. So the lead case in parenting time is the case of Shade versus Wright, 291 Michigan Appeal 17. That is a 2010 case. And what that would say, that says to me that proper cause or change of circumstance has been shown to take a look at parenting time, because there's really not anything to enforce, and children need, everybody needs structure in these areas. I will also note the unpublished decision of Bauman versus Hartman, that decision not being precedentially binding on this court, but certainly persuasive. And I find that poor communication and lack of cooperation between parents does constitute a change of circumstance to revisit parenting time. The relevant best interest factors are found at MCL 722.23J, because it diminishes each parent's ability to encourage and foster a close and continuing parent-child relationship between the other party and the minor child or children. So reluctantly, because like I said, I don't take lightly getting involved in people's business. So reluctantly, I am going to send the matter to the friend of the court for a complete investigation and recommendation insofar as parenting time is concerned. Additionally, there is a request for custody, and it appears anyway that it's not, there's certainly no proper cause or change of circumstance to even do that. So I'm not going to get in that involved, but I'm just going to refer it to parenting time for parenting time. And let me ask you this, Ms. Lachey, are you currently employed?
Yes.
And Mr. Shears, are you currently employed?
Yes.
Okay, so I'm going to send it to the friend of the court. There is a fee for that, and I normally split it. And the fee is $300, so half of that's $150. And they will let you know. Keep in touch with the friend of the court. Make sure they have your correct information. You got to know where to pay the when and where to pay the money. And they will do a deep dive into this. They'll talk to whoever you want them to talk to. They will, sometimes they'll speak to the children, maybe not. And they will review whatever records you want them to review. And then they will make a recommendation to me. And then the parties are free to accept it. They're free to use it as a tool to negotiate from, or they're free to say, nope, I don't like it. And then when that happens, it comes in front of me in by way of an evidentiary hearing. And that's when it gets pretty complicated, because the rules of evidence apply. I can give some grace to people who are unrepresented, but I still have to treat y'all like attorneys. So you can, I'm going to do the order of reference today, and you should be hearing from the friend of the court relatively quickly. I would say if you haven't heard from them by a week, I would call them and make sure they have your proper credentials, because they don't forward mail. So, and I hate for people to run into this problem at this point. Okay. Ms. Lachey, anything further?
Nope.
How about you, Mr. Shears?
No.
All right, you both are all set. Have a wonderful weekend, and Don't stop
Wait.
trying to get this resolved, okay?
I have one question though.
Hmm.
I don't know if this is possible, but is there any way that I can like at least talk to my kids? Like, or
Well, I usually don't start with interim relief. You can file your own motion if she's not allowing contact. And I will entertain a interim schedule of parenting time, but I need more facts. Okay,
Okay.
so if you wish to do that, then bring it on in another motion and let me have all kinds of facts as to what kind of parenting time you had in the past, what you're looking for in the future, what type, this type of thing. Okay,
Okay.
you are all set with me. Have a great weekend, you two, and we're adjourned.
Thank you.
So this is your motion, Mr. Linhout. I have read it. Is there anything you wish to add to it before we hear from Ms. King?
No, sir.
All right, you received a copy of it, did you not, Ms. King?
I did.
Your thoughts, please.
I do not feel that him having the girl's social security numbers is appropriate considering we haven't really even established a relationship with him since he has been out of prison. We have had the visitations. A lot of them have been canceled on both of our parts just due to scheduling conflict, at least on my end, and the girls' schedules, and past issues with money problems on his end with bad things. I'm sorry, I didn't want to say robbery, but and I do not feel safe or comfortable with the girls staying with him overnight, let alone going on the weekends anywhere that's not the supervised visits we were doing at Journeys. And I can say that the girls would not feel comfortable with that either.
Well, I'll give you the last word, Mr. Linhout.
Okay, so I have a full-time job. What was in my past is in my past. That was 20 years ago, 30, 25 years ago. Two, the Social Security numbers. I can't add my daughters to my life insurance policy, and I can't add them to my 401k or my Roth IRA insurance policies as my beneficiaries without their Social Security numbers. As far as the Journeys goes, I feel I do not get quality time with my kids there because you are limited about what you can talk about, what you're allowed to do with them. Journeys is not geared towards kids my daughter's ages. We are consistently told to quiet down. Please refrain from playing with the toys too noisily. So I'm asking for 1 weekend a month so I can get to know my kids better. I cannot have a good relationship with them if I am consistently forced to go to a visitation place that is preventing me from being able to talk to my kids about anything.
Yeah.
Not only that, but the fact that I have to keep paying $60 a week to see my kids, plus bring them food on top of the child support that I'm paying every week. You know, it's
Yeah, I get it. One question I do have, Ms. King, is this. The order for supervised parenting time was entered, I believe, on January 9 of 2024. So it's about a year and a half old. Is that your understanding as well?
Yes, I believe so. I will, but yes.
Okay. So that is somewhat on the outer extreme of supervised parenting time. Usually, when I order supervised parenting time at an agency, it's not designed to be a permanent situation, but it's designed to have some safety while the other side is maybe going through AA or NA or going through domestic violence classes, something. So, is there anything that Mr. Lindhout is supposed to be working to or towards so that at some point this supervised parenting time requirement would go away, or was it intended just to be a permanent fix to all this?
I can honestly say that I showed up to the courthouse a day late and the motion was already filed that we apparently had to go to Journeys. And the only reason why we kept going was how much I work.
Okay.
It was,
Your signal's cutting out.
sorry.
It's okay.
The girls have expressed a lot that they don't want to go on a lot of nights, especially school nights. Both the girls are in band and in Bible club. When school starts, they've done this for the last 3 years, and it's a lot for them. And it's not that we understand that Peter wants to be in their lives. They don't really know him, and the structure that I have set up for them in their lives, they don't really understand what's going on.
Okay. I think she has lost her signal. If I had more of these to do, if I didn't have more of these to do, I could wait around. That is why.
Sorry, hello?
Yeah, I'm about ready to wrap up, Ms. King. I pretty well know what I'm
Okay.
going to do. So what I'm going to do is this. I don't believe that Journeys is supposed to be a permanent solution. But I want to know more about this before I do anything. So I am going to find that there are proper cause or change of circumstances to review the issue of parenting time, not make any changes today because I can't. I have to get some information first. Because I do find poor communication, lack of cooperation between parents does constitute a change of circumstance to revisit parenting time. The relevant best interest factors are found at MCL 722.23J, because it really diminishes each parent's ability to encourage a close and continuing parent-child relationship with the other parent. So I am going to send the issue of parenting time to the front of the court for an investigation and recommendation. At that point, then I can see what the all the issues are after the parties have had the chance to speak with an investigator, and that give the investigator whatever documentation they feel is appropriate. Now, the last question I have is, Mr. King or Ms. King, are you currently working?
Yes, I am.
Okay, Mr. Lindhout, are you currently working?
Yes, I am.
Okay, so the fee for that is $300 or $150 a piece. I will do the order of reference right now, as a matter of fact, and it will be at the front of the court's office probably within a couple of days. So you need first to make sure that the friend of the court has your correct information. Because if they don't forward mail, that could result in a big problem for you. And I don't want that to happen. So if there's any doubt in your mind, I don't care if you're 99.9% sure, just give them a call, go down there and ask them what address they have for you, because it's so much easier than the other route. So you'll be hearing from the friend of the court, and they will look at whatever you give them. They will talk to whoever you ask them to, and then they will make a recommendation, which the parties are free to accept, or they're free to say, nah, I don't really like that. And then we have to have a full-blown evidentiary hearing after that. So I trust if you both are thinking about retaining counsel, it would probably be a good time to do that. Mr. Lindhout, is there anything further?
No, sir.
Ms. King, anything further?
No, sir.
All right, you both are all set with me. Have a great weekend, and we're adjourned. Thank you.
Thank you.
This is Mr. Kessler's motion for custody. I have read it. And did you receive a copy of that, Ms. Lowe?
Yeah, I did.
All right. Anything you want to add to it, Mr. Kessler, before we hear from Ms. Lowe?
Just the child support lower and 50-50. That's it.
Thank you. Ms. Lowe,
Yeah.
anything on your mind?
I do have a couple things to say.
Okay.
So before we even went through the courts, I did give him the opportunity to get the baby, but he ended up changing his number and just went MIA. So that's why I wasn't really comfortable doing 50-50. But he could always see the baby, of course. And then I also had like a question, since he was so far, like how would that work?
I don't know where he is.
He's 2 hours away from me. He's in Detroit and I'm in Grand Rapids.
Oh, well, that's easy to solve. You can meet halfway, or one can bring and the other one can pick up, whatever works. They can figure that out, but we don't have to figure that out today. I'm going to have to send this to the friend of the court so that they can do an investigation and recommendation for what the parenting time should be. I don't find a change of custody to be proper in this case. I don't find a threshold for it pursuant to Vodvarka versus Grassmeyer, but I certainly find pursuant to Shade versus Wright that a parenting time issue is ripe, because obviously the parties got to be on the same page. So what I'm going to do is I am going to reopen parenting time, send it to the friend of the court for an investigation and recommendation. They can tell me, after talking with both of you, talking with whatever witnesses you want them to talk to, whomever you wish them to talk to, and then they'll prepare a report, and the parties can either say, yep, I'm good with that, or they can say, I'm not very good, that I want to do better. That would be your call, but I will send it there. Now there's a fee for this. Are you working, Mr. Kessler?
Yes.
And how about you, Ms. Lowe?
At the moment, yeah.
Okay, so there's a fee for this. It's $150 each. So I'm going to order that the fees be split. And I'm going to do that order of reference today. And you should be hearing from the friend of the court shortly. The only thing I ask is you make sure they have your correct mail because they don't forward it. And I don't want to see anybody miss anything because of that. Okay.
Okay.
All right.
All right. We'll see what the friend of the court comes up with after they talk to everybody. You have a great weekend and good luck on this. And we're adjourned. Thank you.
Thank you.
Good morning.
So I remember we
We've seen you a couple times.
Yeah, there was a motion, and I know in December.
Yes.
And this motion requests payment for medical bills for one of your children who, according to the motion, he was injured while on spring break with his father.
Yes.
Obviously, the friend of the court has their rules about a year. So I take it what you're asking me to do is to enter an order making Gary responsible for 66% of the $3,246.06 amount, which would roughly be $2,142.39. Is that what you're asking me to do?
Yes. At the time, though, I did have my portion of medical would have been $807. So just to make sure that that was taken out because I have paid these bills already.
Yeah.
And then also, unfortunately, some bills are still coming in from this data service because they're fighting, thinking that it was something to do with a car accident. So I'm still getting letters from the insurance company asking if another party was involved or if auto insurance was connected. So I don't know if there's something that you can do to put on if there's anything concerning this date of service that his 66% would be in effect then, or if I need to file papers again through friend of the court, but they won't take it because it's over a year old.
Yeah, I think what you're going to have to do is come back and see me.
Okay.
Because I can give you what you asked for today. And I think that, and correct me if I'm wrong, that amount is $2,142.39. Is that what you come up with?
Whatever the total amount, which I think was that 3,000 whatever, but then my portion was $807 that I had to pay before he covered his 66%.
Yeah, okay, so it would be 3246.06 minus 807.
Yes.
Okay, let me do that math here a second. It would be I want to make sure to get this right. It would be 3,246.06 minus 807 divided by 66% equals, wait a minute, I think I did a plus instead, because that wouldn't work out. 3,246.06 minus 807 equals 2,443 times 66% equals, that's $1,609.78.
Okay.
Okay.
That
So
sounds...
I'll grant your motion for that amount what you need to do is prepare an order. You have to go to the Legal Assistance Center. They'll help you out with that to get to my signature. And but I'll grant your motion. Hopefully your son is doing okay.
He is. It's a year later, but yes, he is. He's still accident prone, but he's good. Can you give me that? I'm sorry, that amount again. It was 1,600 what? I just want to make sure I get the number straight.
$1,609.70, technically 78 cents.
78. Okay.
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 And you can put in there that he shall be responsible for payment of that within the next 30 days.
They don't just add it to his child support agreements or anything like
They
that?
could. They could.
Okay. I'm
rather
fine
get
with
it-
that.
I'd rather get it up front for you,
Yeah, well,
you know.
yeah, I just don't
But
want
you
to put
can
him in
put
a,
in there, he shall pay it in 30 days. If not, it should be added to his child support.
okay,
records. You want to do that?
okay.
Okay.
All right, thank you.
You bet. Good luck.
Thank you.
But so I read your motion. Is there anything you want to add to it?
I did want to add on there, he has had an unstable housing frequently, and also just with his pattern of anger of posting stuff on social media about all of this situation. He's also demonstrated inconsistent parenting time. What we had was every other Wednesday to Sunday, every other week. And he stopped doing that back in October, November, I want to say. And then he would just ask here and there if he could see our daughter, and I would tell him yes. And he would always just reach back out like, oh, I can't do this, I can't do that. So it's just been very inconsistent with the parenting time, the child support, and also with like his housing situation. Back in June of last year, he contacted my partner and said that if we could keep our daughter until he was able to get back on his feet. And he hasn't really reached out and said that he's back on his feet or that he's really gotten a job. So I don't know like what's going on.
Okay. Because you understand there's a whole line of cases that say if somebody is having problems and they voluntarily reach out to the other side and say, okay, look, I'm having problems. I need you to take her. Public policy says that's a good thing because otherwise they would run into difficulty with everything else. But it doesn't sound like he is doing much anyway.
No, and now he has a new partner who has been sending things to my phone. And he also has a DV charge open right now.
That's not a good
thing. Yeah, so it's a lot.
I will find, because you already have physical custody.
Correct.
So I will find that there's been proper cause or change of circumstances pursuant to Vodvarka versus Grassmeyer, 259 Michigan Appeal, 499, the 2004 case, as well as Shade versus Wright, 291 Michigan Appeal 17. The requisite best interest factors are factor C, the capacity and disposition of the parties to provide the children with food, clothing, medical care, etc. Factor D, the length of time the child lived in a stable, satisfactory environment and the desirability of maintaining that. So I am going to do what I can for you on a Friday morning. I'm going to reopen the issue of legal custody
Okay.
and parenting time.
Okay.
And I'm going to send those to the friend of the court for an investigation and recommendation. Are you currently working?
I am. Yep.
Okay. So what I have to do, Yvonne, is I have to stick you with all the fees. And the only reason I'm doing that, and it's 300. The only reason I'm doing that is because if I split the fees, he's just not going to make the payment. And then that stops everything.
Right.
And I don't want that to happen. But I will, if it gets to a hearing in front of me, I will order that he reimburse you the 300 that you're paying now. But this way, it looks like this way, there's no doubt that he's gonna, that you'll be able to get into court on that issue. Okay, makes sense.
Yep.
All right, make sure the friend of the court has your correct information because they don't forward mail. You are all set with me. Have a great weekend.
Thank you. You as well.
So I read your motion, Ms. Reyes. Is there anything you wish to add to it before I hear from Mr. Hatchett?
No.
Mr. Hatchett, how about you?
Not well, just received the motion yesterday via text, but an email. So I'm cool with just continuing to move forward. And then just trying to filter through her motion, what she's saying. As far as the what you granted prior to us for the investigation, just wasn't able to have the money. So I was asking if we could waive the fees for that investigation. I'm open for that. If not, then it's totally up to you, of course. Just not refusing support of my children. I'll just limited income and things like that, but also help. Our oldest son just had surgery, and he have a balance that I've been trying to pay off as well. Plus lining him up to get him back to school, and also school supplies for both the oldest and JH, who we hear about as well. So I'm open to that. And then just having to communicate with the youngest, JH, a 12-year-old, it's kind of been difficult as well. I don't have really much to say. I'm just open for the investigation.
Okay. See, at some point, all right, I have to hold parties accountable, okay? And let me tell you what I'm getting at. There's been previous motions filed in this case on March 28 of 2025, on 5/9 of 2025. On the 28th of March, I heard a motion for parenting time, as the last parenting time order was 11/8 of 19, which provided for an extensive schedule of parenting time. I adjourned that motion, and another motion was filed and heard on 5/9, and that was plaintiff's motion for support. Once again, I did an order of reference for child support parenting time, and nobody paid the fee. And it was dismissed on June 26th of 2025. So why aren't we now in the process of simply holding both of you accountable for what I consider poor judgment and not following the orders? Why these amounts weren't paid, I think, twice. Why, instead of waiving the fees, why don't I just deny the motion outright? And then you two can figure it out. You two can find somebody that doesn't charge a $300 fee to figure this out. I mean, at some point, I have to hold people accountable. When is that time? That's what I don't understand. It's a court order that you pay this money. It's not a suggestion. It's a court order. And that's what's got me perplexed of why we have to continue to do this and both of you ignore my order. If you're going to ignore that order, what makes me believe you're not going to ignore other orders? And that's where I'm at. I'm struggling to hold litigants responsible for their own decisions. And that's what's got me more bothered than anything, is that we have done this now. How many times have we been to court? I do the same thing, and then the parties just don't do it. Okay? Are you both working? Are you working, Mr. Hatchett?
I am.
How about you, Ms. Reyes?
I am.
All right. I'm going to do this one more time.
Okay.
Once more. And if the fees aren't paid, then find another courtroom. Okay? Go ask a minister to help broker this deal. So I'm going to re-refer it once again to the friend of the court. The fees are split, $150 apiece. You'll be hearing from the friend of the court, and let's get this done. Okay?
Yes, sir.
All right. You are all set with me. I'll send it over there today.
All right.
All right. Good luck.
Thank you.
This is your motion, Ms. Soto. I read it. Is there anything you want to add to it before I hear from Mr. Soto?
Yes, I just wanted to make it clear that my main priority is, breaking the cycle of abuse in our family and to prioritize the children and their stability. I prioritized and committed to co-parenting with Jesse. And from what I've seen and what's been shown through my children, I'm just, I have to go through with this to keep them stabilized. And that's my main goal.
Thank you. The question that I have is, one of the things kind of disturbed me in here, and I just want to get your thoughts. How old are your children?
So my oldest, Nivea, just turned 17.
Okay.
And then Naomi is 15 and Nicholas is 11.
Okay. I just wanted everybody to understand that at some point, if I have to talk to the kids, I will. But I generally don't leave those issues up to the kids. Okay. Just like you wouldn't do if one of your kids says, I'm not going to the doctor, I don't want to. You would do everything in your power to get them there. And that's what I do for kids that don't want to cooperate with parenting time. What do you think, Mr. Soto? What's going on here?
Your Honor, I don't know what's going on. I didn't get no paperwork or nothing. I just got a text on Wednesday reminding me that I had a court date, and I called my lawyer yesterday, and she notified me I did have a court date with you. So I don't really know I didn't get no paperwork or nothing, Your Honor.
Oh, okay.
So I'm kind of confused what's even going on.
Well, let me see if I can straighten it out for you.
Thank you.
It involves a motion with about your kids. and it's not particularly long, but Ms. Reyes violated the first rule in my courtroom by attaching a bunch of text messages, which I hope I never see again. Write that down, Ms. Reyes. I don't want any more text messages. If they're important, then you got to type them out because I can't read them hardly. It's hard to follow them. But it says here that on July 17, Ms. Reyes sent a copy of this motion.
Ms. Soto?
Or I'm sorry, Ms. Soto sent a copy of this to, oh, it's number 20. That's why I was confused. Sent a copy of this. What the actual date is July 21. So she sent a copy of this to you, at least she says, at the I can't even make out the address. Alpine?
Yeah, I do live on Alpine.
1544?
1532 Alpine.
Oh, you had the wrong address, Miss Reyes. Or Miss Soto, I'm sorry. So you never got this because the address was wrong. Right?
Yes, sir. I never received it.
Okay. All right. Did you write down his correct address, Ms. Soto?
So
I can't hear you.
Okay.
Go ahead.
I believe I did. I know his address, and I've also used the GPS to confirm.
Well, you've got it on here, 1544, and he doesn't live there.
That's the last address that I had on my GPS. So I'm not sure what happened. Maybe I'm not sure.
Okay. Well, I always want to make sure everybody is has got all the information I do.
Absolutely. And I've contacted Mr. Soto many times asking for us to work this out between each other. But due to his tactics, I felt that this was the best way to get the courts involved.
When did you ask me?
I don't, hang on. This isn't back and forth.
Sorry, sir.
I don't, I appreciate that. Because the last group of people you should be wanting to jump into your lives are the court, because nobody, I will guarantee you this, if you both ask me to make the decision, neither one of you are going to be happy. It's just the way it works out. But what I'm going to do is this. I want Jesse to have what I have and what you have, Ms. Soto. So I want you to renotice or reschedule this and send it to where, Jesse?
It's 1532 Alpine Northwest.
Okay.
49504 Grand Rapids.
All right, you got that all?
1532 Alpine Northwest, GR, Michigan.
You got it.
Okay.
I'll send that. I'm going to postpone this, so you won't have to pay another fee, which is good. So you renotice it, send it to his correct address, and then he'll have everything we have, and then we can get down to business and figure this out. Okay?
Absolutely.
Is there any way that
see you both? You all set?
Thank you.
I was just going to ask if there's any way that she could just talk to me and we could try to work this out.
Of course, but but I can't force that. I prefer people talk and work things out. But if they don't, there's not a whole lot I can do. What you two ought to think is maybe find a mediator to help you. They're in the phone book. Maybe they can help you. So, but I think it's a good idea. Agreements made between the parties last longer, but I'll leave that up to your wisdom. Okay. Have a
Thank
great
you.
weekend.
You
Thank you.
too.
Thank you, Your Honor. You
Bye-bye.
too.
Bye. So, I received a copy of your motion, Ms. Rodriguez. Did you get a copy of that, Mr. Winston?
Yes.
Okay. Anything you want to add to it, Ms. Rodriguez, before we hear from Mr. Winston?
Yes, I received his packet yesterday, late evening, so I got to do like a quick skim of it. And I just wrote down some things regarding that, and also just some things that I forgot in my motion in general.
Did you write down, I never want to see a response like this, checked full of text messages? Write
Yeah,
that down. Make that sure that's number one.
no, I completely understand, because text messaging can definitely be construed in different ways for sure. So, I read that. So Zayden has had 57 tardies in the last year.
Ouch.
He has been suspended due to fighting. And I feel like Mr. Winston has a big part in that, due to the fact he brought those people into our child's life, and he fell out with the father due to a football altercation. And the little boy ever since then has picked with our son, to the point where he had to get into an altercation at school, and I was not notified by the school that he got suspended, because Zachary told the school not to contact me because I don't have rights, supposedly. Zachary has popped up to like multiple like our location. I coach softball for CA Frost. And they were like a football team up the hill. And they were doing drills or whatever. One of the coaches recognized me, spoke to me. Zayden was like, "Oh, what do you do?" And he's like, "Oh, I coach football. If you want to come check us out, come check us out." And, our son asked, he's like, "Is that okay, Mom?" I'm like, "That's fine. I can see you from here." Or big ordeal happened. Mr. Winston made a big post on Facebook, making it seem like it was something that it wasn't. Then continued on to text at me saying, "Why would I put him in something?" And this, that. He wants full control of Zayden's football career. And then next thing you know, he pops up where we are doing drive-bys. Our son realized that was him and tried to run to the car, but by that time, Mr. Winston pulled off. He's always interfering with my parenting time. My son has came home stating that him and his mother have said very mean things about me to him. Mr. Winston sent his mom to my home with the police harassing me over football equipment. He gives my phone number and my address out to his family members without my permission, and they get to harassing me. He puts our son in the middle of discussions after me and him already had a discussion, and I already said no. He has stolen so much of my parenting time, weekends, taking him out of the state on my time. I told him I was concerned about the football league that he decided to put our son in, as there is multiple fights that go on up there, multiple people around with guns on their hips. He has a gun in his fanny pack.
So you guys got,
and like I said, he also advised that I didn't have no rights over school and doctor's offices and doctor's appointments or whatnot. I don't never hear anything about that until after the fact.
So how can we fix this?
Sorry, say that again.
How can we fix it?
I'm open to whatever. All I ask is for more time with my son and not to be interrupted on my time, because I don't interrupt him. I respect him as a father to our child. And I've been more than lenient with switching weekends, letting him pick up our son and drop him off to make sure he gets to events, everything. I've been way more than lenient, but at some point I have to draw the line to where you're not respecting my time with my child. And when I say I got plans, then it should just be that. It shouldn't be more to that.
Okay, thank you. Mr. Winston, what can you tell me about this?
A lot of it hasn't been already addressed in my response, or so. As far as some of the dialogue that just transparent now, our son ZW is a great athlete. Most of the time, he has been always around structured environments. He knows that he always has to do something productive, outside of school. As far as the environments or so, the equipment was by my mother. She is not okay with the environment that is with the defendant's husband, which is why the police was escorted her to go retrieve some equipment that she did not provide back to my mom that she bought for ZW after an incident that was at a practice where Alex had dragged him off the field during an altercation in front of parents and teammates, coaches, that one parent actually spoke about and reached out to, provided her dialogue, what she's seen as well. Phone number was only just to request for Zayden to attend a birthday on her weekend. Majority of the time, we have always discussed and worked out if there's a time where we can switch weekends in order for Zayden to do his extracurricular activities. In this case, we're talking about sports. He is a traveling athlete, so he is constantly on the road. Oftentimes I give all the information to Alex when I can. This is the time, this is the place. Can you be there? If you cannot be there on your time, then can we work out a agreement in order to switch weekends? And also, I have also provided weekends in order to have back as well after the traveling dates have proceeded. He has been to multiple colleges and whatnot as well. So all of this is just in response to what Zayden loves to do. Zayden loves to play sports. He is a straight A student as well. So there has not been any issues as far as school. As far as the suspension, he was bullied. He then retaliated. The school followed proper protocol as far as contacting me. And if they could not get in contact with me, then the next was to contact Alex. In response to that situation, once I arrived to the school, before that principal proceeded to explain the situation, I actually called Alex and placed her on speakerphone so that both she and I can speak with the principal concerning that incident as well.
Do you think you folks can communicate effectively on this case, or do we need something to help you communicate?
We have in the past have tried to use an app that was suggested by Gottlieb at the time. However, that app communication just ceased on that for one reason or another. I still have it active on my phone. I just know that.
What is the name of it?
It's lost in all of the other apps that I have. There was a parenting app.
I know.
That she suggested at the time.
Your Honor, may I speak?
You've spoken quite a bit.
Oh, okay, sorry.
But give me a chance to put my 2 cents in here, because you two have a gift of gab. Okay, you say you guys talk a lot. Did you find it?
No, I do not. I have a new phone, so that app is not active on this phone. It is in my cloud, though.
If I said it to you, would you know it?
Yes.
Is it Our Family Wizard?
No.
Okay. All right.
It's not that one. I never believe it was orange at the time.
I'll give you the last word, Mr. Rodriguez. Go ahead.
Oh, I was just gonna say the reason why we stopped with the app was because Mr. Winston said the app was not working for him. And he said it was what did he call it? Childish. And we should be able to talk like adults. So we started via text
Well,
messaging.
when adults act like children,
App closed. That's what it is called. Your app closed. I'm sorry.
when adults act like children, you have to employ different methods. So there's a lot of things I can do with this, but I'll straighten some issues out for you. First of all, if people are violating parenting time orders, then you have to use the friend of the court process. That's found at MCL 552.644. They're online. You can file it with the friend of the court, and they will try and meet with the parties and discuss it, see what they can do about it, those types of things. So that's one thing I can tell you. The second thing I can tell you is that the last custody order was on 12/3 of 21. And that provides joint legal custody with physical custody to plaintiff father. By virtue of Ms. Rodriguez having joint legal custody, she is absolutely entitled to a say on doctors, schools, all the major decisions, important decisions affecting your son. Okay? So she has that. Now, whether that creates a problem for both of you, because the remedy is very simple. If one of you thinks he should go to Burton Elementary and the other one thinks he should go to C.A. Frost, I get to break the tie, okay, after an evidentiary hearing. And after a couple of those, I'm going to say, look, you guys cannot be joint legal custodians because you can never agree on these things. Okay? But she has absolutely every right to be at doctor's appointments, to be informed of when they are, to participate in major decisions. She has absolutely that right to do. So I'll straighten that out. What I'm going to do is I am going to start small and work my way up if I need to be. I want, and I'm going to order that both parties enroll in our family wizard within the next 30 days. It's another parenting app, but it's a little bit more it has a lot more to it. It has calendars. It has things like that you can post doctor's appointments, any other appointment, practice schedules, all of that. And it helps parties who have difficulty communicating. It gives them a hand. Okay.
Okay.
And I want to try that out along with the complaint process. And now everybody's on the straight and narrow with what Ms. Rodriguez has as far as what legal custody is. And we'll see how that goes. And if we have to come back, then I'll do something a little bit more dramatic. But I'm going to try these things out first. Okay?
Sure.
So let's give it a shot. Hopefully everything will go well. Okay?
All righty.
You both are all set with me. Thank you. So this is, it looks like George's motion for an objection to the friend of the court. So what did the friend of the court do that you object to?
So the last time we were here at court, you ordered that we go to review parenting time with friend of the court, and we pay $150. She pays $150. So I kept keeping in track with friend of the court, and they told me that she wasn't going to pay the 150. So I asked them what I have to do so I can get parenting time, because I've been trying to get more parenting time with my daughter. And they told me I had to file an objection, and now we're here. So, yeah, that's pretty much why we're here, is because she didn't pay her 150. And then it kind of got very frustrating because she didn't pay her 150, and at the time she was going on vacation to Arizona. So I'm like, you ordered a court order and she just blows it off like nothing. So it's a little frustrating, and I got to go through all these loops to try to do what I have to do to get more parenting time. So it just feels like she just blows it off and doesn't matter what you say. So
It doesn't.
no, it does matter to me what you say.
Miss Gonzalez, what say you?
I did travel to Mexico, but it's not like he's putting it. I went to Mexico because my brother sent me money to take stuff to my mom because she moved back to Mexico. So we needed to take her stuff. He knew that my daughter was coming along with me. I didn't pay the 150 because he has the support. He lives with his parents and he works. I am here in Michigan by myself. All my family is in Arizona and Mexico. So I get financial help from the government. And I went to the front of the court as well and tell them how we can waive the fees. And they tell me the same thing about submitting a paper to talk to the judge and kind of see if the judge can help me waive the fees.
I'm not waiving the fees.
Okay.
I'm not. It's $150.
Mm-hmm.
You can't come up with $150 for
I get assistance from the government.
That's besides the point. It's $150.
Mm-hmm.
Okay. And you can't tell me that something this important, okay, that you don't have $150. You don't have anybody you can borrow it from?
Like last month, I didn't work for a whole month. I work in construction, so I get work here and there. I had to pay my insurance, my rent, my phones, my kids.
Okay, I got the perfect solution then. George, here's what we're going to do. I'm going to resend it over there. I'm going to have you pay the $300. And then when we get to an evidentiary hearing, I will order Ms. Gonzalez to pay the $300 back to you. So she just cost herself $150. But I don't want to stop things anymore. And if anybody else decides to violate one of my orders, there's going to be a lot more at stake than $150. So I hope you both know that. So I'll order you pay the fees, George, but you're going to get them all back from her. Okay.
Okay.
All
Okay.
right. I'll do the order right now.
Your Honor, just one quick question real quick. So they haven't funded me back the 150. Can I just go and pay the other 150? And
yeah, however you do it.
Okay, I'll contact them and I'll pay the other 150. So that's because right now the money situation is not even the thing. It's just having more time with my daughter, because there's a lot of things Lisbeth's doing around Juliana, which is very alarming, and just things that's happening in the household. So
I already ruled on that, George.
Okay.
I said we're reopening this up.
Okay. Thank you, Your Honor.
It's just.
So when am I paying the $300 back to him?
When we get to a hearing, if we need it.
Okay.
Okay.
Okay. Thank you.
All right. I'll do the order today.
Thank you.
Thank you. Yep.
Bye-bye.
So this is your motion, Adam. Give you the floor. Tell me what you want to. And then we'll hear from Megan.
Absolutely. So I was asked by Megan to pay half of the car. And I looked over our judgment of divorce, and what the judgment of divorce says is that the plaintiff, which is Megan, is responsible for all loan payments for the vehicle, and that she shall not hold the other party responsible for any debt associated with the vehicle.
Yeah, I see
So
that.
absolutely. So my ask on this is to ask for that judgment to be enforced, and if possible, if my name to be removed from the loan for the vehicle.
Well, let me ask this question. How much is owed on this car?
According to the most recent, sorry, Your Honor.
Go ahead.
Would you like me to speak?
Yeah, that's fine.
The most recent statement issued July 9th, which was attached with my reply to motion, currently states the total balance owed on the vehicle. Good Lord. Sorry, I'm having issues with my computer screen.
I think a lot of people are today. It's kind of one of those days.
So the current amount as of the July 9th statement owed is $21,871.
Wow. It's a pricey car for a 2020.
It is a very pricey car. It was purchased in July 2021. Due to both of our credit scores at the time, we ended up having an 8% interest rate. And so my reply to the motion included that as of current, I have been paying the entirety of the car loan, and therefore I feel I am meeting that responsibility. However, the discussion around removing his name from the loan, as addressed in my motion, I reached out to my financial institutions. They had me go get an evaluation of the car. I did. And just due to the sheer amount of negative equity in the vehicle, they are refusing to refinance the car. And I asked around to a couple other local credit unions, asked for their input, and they kind of said the same thing. Just with the value of the car versus how much is owed on it, nobody's comfortable refinancing the vehicle. I went and spoke to a couple dealers in the Orem, Utah area where I currently live, and they had all advised that that amount of negative equity would also be impossible to roll over into a trade. The only other option Toyota Financial gave me was to sell the vehicle, and to sell the vehicle, both would leave still over $10,000 loan owed to Toyota, which would still, as of the most recent statement, be a joint debt.
Well, that would be if you sell it to Toyota, right?
That would be if you sell it to Toyota, who is the financer on the vehicle.
Right. Yeah. So
but even if
you don't have to sell it to Toyota if you didn't want to. You could sell it to Tom Smith down the street, and if he gives you what's owed on it, you can just pay Toyota off, and they're happy. But then you don't have a car, right?
Which I also addressed in my letter, stating that selling the vehicle would create a hardship for me, as I earlier this year broke my right foot, and I have been diagnosed with a condition called Charcot foot, which is a condition that causes permanent deformity to my feet. And therefore, being without a vehicle would create just a hardship for me in terms of getting to work and getting to my medical appointments.
Well, let me ask you this.
Yes, sir.
First of all, when did you send this response to this motion to the court?
The motion is dated 7/17 of 2025, and it was mailed from the Orem, Utah post office on 7/21.
Yeah, because I didn't get it.
And I did confirm with Adam on Wednesday that he had received it in the mail, so I was kind of worried that it might not have gotten to you.
Well, there's a lot of layers of, there's a lot of people touching the mail that gets, it could be on someone's desk, who knows? So, was there a time when you were not making the payments, or have you always made the payments?
So we took out the loan in January of 2021, and at the time, up until the point of our divorce, we had asked for a few deferments from Toyota just due to either him or me being unemployed. Other than that, up until October of last year, the payments were made from joint bank accounts. After that, when I moved out to Utah, I took on making the full payments of the vehicle.
But you
And I have been
understand,
making them since then.
you understand though, that whenever there's a joint asset and a joint debt, which this is, that even though you two are not together anymore, that your financial practices impact Adam to the point where if you don't make the payment, if you try and negotiate or something along those lines, they hold his credit hostage for that.
Yes, sir. And since our divorce, we have been 2 months behind on payments. We were at the time of our divorce. I have been attempting with everything I can to get fully caught up. However, I have been making a monthly payment every month. And the only thing preventing me from getting caught up on the late payments that we have is the fact that I had broken my foot and have been working less than a full-time load, which has been discussed with my employer, and they've been very accommodating. I've tried to make up hours where I can.
Yeah, I mean, it's going to be a situation like this. I need all payments brought current in the next 90 days and no payments missed, or else the vehicle gets sold. That's the bottom line. I mean,
Yes, sir. I can be caught up within 90 days.
okay. And then all the payments made, because I looked at your judgment, and this is kind of what happens, and it's not either one of your faults. It's the nature of being unrepresented by an attorney. And a lot of people do this, and this is one of the drawbacks, is that the provision that you have, the judgment provides that Megan is in fact responsible for all payments and debts associated with that vehicle. And Adam is asking for his name to be removed from the title. That's not an easy task ever, and the judgment doesn't provide for that. The judgment is the written contract between you and Megan, and a lot of attorneys would have put something in there along those lines, and it would have said, you have to, if the payments are, if there's one payment missed, then the car can either be repoed by the other party or sold or whatever, but none of that's in here. So we have to kind of fly by the seat of our pants with our own remedy here. So what I'm going to order is that all payments on the 2020 Camry be made current, all past payments be made current within the next 90 days. And that if a payment is missed for whatever reason, then the vehicle is going to have to be sold. And you need to, since it's your motion, Adam, you need to prepare an order to that effect.
Okay.
And you have to go down to the Legal Assistance Center on the 5th floor here. They'll show you how to prepare that.
Okay.
And then they should, you should be hopefully okay. Hopefully Megan's foot issues work out, because it sounds painful to me.
It does. It does.
And
Thank you.
And obviously, I don't want to cause any more grief for anybody. But I think that's a practical solution. So do you know what I need the order to say, Adam?
I do, from what you told me, I think I have a little bit. But as what you said, that 5th floor, at the courthouse, they should be able to help me a little bit.
Yes, they'll help
Okay.
you a little bit, but I just want to make sure you understand that all past due payments be made up within 90 days from today's date, August 1, and that if any future payments are missed, the vehicle will be sold, and either the proceeds split or what's owed on it is split. I mean, it could be what Megan's telling you is there's a lot, which happens a lot in cars. There's some negative equity going on. So who knows? But I think it sounds like Megan is over the hump, so to speak, to getting all these things done. So let's hope.
Your Honor, just for clarity, after those 90 days, once I am fully caught up, is that missed payment, does that go for the length of the loan, or does that go just for that 90-day period?
No, that goes for the length of the loan.
And if it's
missed payments.
And if at any point I need to sell the vehicle just to get a different one, anything like that, will that same split apply?
I doubt it. Well, no, that same split wouldn't apply because it's your car. Okay, so I'm just saying that
I was discussing, I meant for the loan, since the loan is a joint loan.
Well, that's obviously a fight for another day. I don't know. I'd have to rethink that because I'm not really necessarily excited of putting somebody in the behind the 8 ball with a loan on a dead horse. So that's what it would be, right? Sell your car, you owe them a bunch of money. You can get a good price for it, but let's just get through this and get you guys back on track first, okay?
Yes, sir. Do we need to have a follow-up hearing at all?
I don't think so. You know where to find me, both of you.
Okay. Thank you,
Okay.
Your Honor. I am also looking for representation as well if I need to.
The testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I swear.
All right. You can put your arm down. So, I have been presented with a request to enter a default judgment of custody. A complaint for custody was filed on April 23rd of 2025. An order for alternate service was entered on June 5 of 2025. It was served on May 7 of 2025, and the default was entered on 6/18 of 2025. So I've reviewed the proposed judgment as well as the UCSO, and I want to cover a couple of things for you, okay? Because some things are not, some things are not correct in here. I'll cover them with you, and we can make sure that we can get it done for you today. But some changes have to be made in this judgment. Do you have the judgment in front of you?
No, I haven't received any updates from the case. I just received the notification that today will be, this hearing will be taking place. But I mean, other than that, I haven't received anything through mail.
Well, you probably wouldn't have received it because It's the document you prepared. You prepared this yourself. You know what I mean?
Okay.
Okay, so it's a lot easier if you had it with you, but I'm going to go over it with you first. So paragraph 6.
Yes, sir.
Restrictions on moving the child or children more than 100 miles away. You have checked the box, neither parent shall move more than 100 miles away from where they lived at the beginning of this case. The children have a legal residence with both parents. However, you are asking for sole legal and sole physical custody. So box 3 should probably be checked instead of box 1.
Yeah.
Box 3 says one parent is granted sole legal custody of the minor children. So MCL 722 does not apply. Do you wish
Okay.
me to make that change?
Yes, Your Honor. What I would like to have is the sole custody of my kids, and yeah,
I got it.
I mean,
We're
that's
gonna
it.
take this. We're gonna take it one step at a time. You just bear with me, and I'll get it straightened out for you. Okay.
Yes, Your Honor.
So in paragraph 9, you have the plaintiff, and that's you,
Yes.
shall have a specific parenting time according to the attached parenting time addendum or mediation agreement. You don't have an addendum or a mediation agreement. Okay. So you check that box wrong. That shouldn't be box 1. It should be either box 2 or box 3. Box 2 says parenting time shall be reasonable and mutually agreed upon by the parties. Or the third box is parenting time shall remain as previously ordered. So which one of those 2 boxes do you wish to check?
Like I said, I want the custody. He's not here, by the way, Your
All right,
Honor.
then hang on. You're repeating yourself. I got all that. I'm trying to
Yes.
get your judgment in order.
Yes,
Okay.
sir. Yes.
So it sounds like to me that you would that the more appropriate box would be parenting time shall be reasonable and mutually agreed by the parties. Because if you don't agree, then there's no parenting time. Make sense?
Exactly. Yes. Yes, Your Honor.
Okay, so let's check box 9B. All right. Box 10 is technically correct, but you have made a big mistake on the uniform child support order. Okay, it's not correct.
Okay.
You need, see, there's 4 children in your case, correct?
Yes. Yes, Your Honor.
So it should have information or box or money amounts for 4 different children, not just 1. Okay. So what I can do is I can put child support is reserved, and then you don't need a UCSO. Then you need to go to the Legal Assistance Center, and they can help you prepare an actual one. Okay.
Okay.
Because this one's a mistake. So with those changes, and I'm going to take out the UCSO. Let me ask you these questions.
Yes, Your Honor.
Have you read and understood the judgment of divorce?
No, I haven't read it.
Okay, why would you sign something you didn't read?
Oh, over there, the papers that I entered them.
Yeah.
I think I've read them, but I mean, I don't remember them. By heart. I work at night, Your Honor. So I'm like, okay.
So do I.
I'm a zombie right now. So yeah, if you can, like, I don't know, refresh them to me, that will be okay.
I'm just saying, this is the judgment of custody that you prepared. You prepared this. I just want to make sure you read it, you understand it, and you find it to be in your children's best interest.
I believe so, sir.
Okay. And you believe it to be fair and equitable?
I don't want any child support from him.
Okay. All right. Now, I'm going to go ahead and sign this judgment of custody with those changes. And what you need to do, if you want to, you don't have to, if you want child support, you would have to go to their office and they can help you get through that. But I will enter this judgment right now. Okay.
Okay.
Any questions for me?
So I should go to the legal aid again and
Yeah, and tell them you messed up your uniform child support order. They'll know
okay.
what you're talking about.
Okay, then I'll go over there.
I wish you the best of luck in the future, okay?
Thank you, Your Honor. I appreciate it.
You are all set with me. Thank you.
Thank you. Have a great day.
You too.